is this not straight? All rise. The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes, the Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Good morning, everybody. I am Lucy Inman and presiding here today with my colleagues, Judge Valerie Zachary and Judge Jeff Carpenter. We have a few matters on the docket today, and the first matter is Michael Mole versus the City of Durham. Before we start, and it looks like everyone already got the memo, but just for the record, the consensus of this panel, since everyone participating in this oral argument has followed the guidelines, and I think we're all vaccinated. There's no need to wear a mask. If anyone in the courtroom, other than when you're arguing, feels more comfortable wearing a mask, that's just fine. But it's really nice to be back in person and almost back to the way things used to be. So the first case is Mole versus City of Durham, docket number 19-683. And counsel for the appellant, are you ready to proceed? Do you wish to reserve time for rebuttal?
Yes, we hope to reserve 5 minutes of time.
Okay, Mr. Soar from our clerk's office will make sure that you know that, and I think your light will turn yellow when you are how many minutes away from?
5 minutes.
Okay, and so when the light turns yellow, you're going into your rebuttal time.
Sure. Okay.
Okay.
May it please the court, I am Travis Payne of the firm of Edelstein and Payne, and with me today is my colleague and co-counsel, Michael McGinnis of the McGinnis Law Firm. We have the privilege of representing Sergeant Michael Mole. I will address the fruits of labor claim under Article 1, Section 1 of our Constitution. Mr. McGinnis will address the equal protection and arbitrary and capricious government action claims. He's the one who's going to be up here when the yellow light comes on.
Okay. Mr. Payne, if I could ask you, you know, this case was briefed more than a year ago.
Yes.
We invited counsel to submit supplemental briefing and didn't receive any, which I take it means that counsel doesn't believe there's any case law that's developed since the original briefing that should affect this case. If you have thought of any, please let us know that. And I would really like to ask you to walk us through the Tully elements as applied to this case.
Certainly, Your Honor. The Tully court specified 3 elements, and all of those elements are set forth in the complaint. Those elements, as you're well aware, a clear rule or policy that furthered a legitimate governmental interest, the employer violated the policy, and the plaintiff was damaged or injured. There's more than one policy referred to in the complaint that the city and the police department violated, but the primary policy that we rely upon is General Order 4030 Revision 3, which is the policy having to do with hostage and barricaded suspect negotiations. Now, I need to point out to the court there's an error in our brief. At various points of our brief, it refers to General Order 4030 Revision 4. That is incorrect. The policy that applied to the events at issue was Revision 3, and consistently in the complaint, we cite to 4030 Revision 3. That policy, among other things, required that negotiations be conducted by a team and that members of the hostage negotiation team be dispatched to the scene of a barricaded subject negotiation. That was not done. Sergeant Mole, in May of 2014, went to an FBI training school. He then joined formally the hostage negotiation team. So he was a member of that team, but I believe there were 7 or 8 other members. And at about 4:25 in the morning, when he was the only member of the negotiating team on duty, is when he was called to get into the thick of this very intense matter. Again, the policy required that at least 2 other members of the negotiating team be dispatched to the scene and participate. And one of those members, Mr. Mole, Sergeant Mole, was one of the junior members of the team. There would have been a team commander there on the scene for the negotiating team. That team commander would have participated in and approved all decisions. The decision that got Sergeant Mole fired, as defendants make clear in their brief, is that he negotiated a surrender agreement in which the suspect, who was threatening suicide and had a loaded weapon, and potentially, if he didn't commit suicide himself, he could have come down the stairs, guns blazing, and been killed, and in the process injured police officers or others. Sergeant Mole, having no one else on site to assist him in the negotiations, made the decision to agree that when the suspect surrendered, left his loaded weapon upstairs, put on Sergeant Mole's handcuffs in front of him. Sergeant Mole tossed those up the stairs and came down slowly with his hands out in front, that if he did that, he could smoke the blunt. And he was allowed to smoke about half of it in the living room of that apartment.
Excuse me, I just want to make sure that I've got a correct understanding of this. Sergeant Mole did not provide him with marijuana, did he?
No, it was behind his ear. The suspect had it behind his ear. And
Did Sergeant Mole provide him with a lighter to?
it was the suspect's lighter. He had been patted down. They had removed the lighter and cigarettes. And so when the suspect sat down, the lighter was returned to him. The suspect lit the blunt himself. The suspect pulled the blunt. We've alleged that specifically in the complaint. So those are the facts that resulted. There's another policy. So policy, General Order 4030, Revision 3, the police department, we say clearly violated it, but for that violation, but for there being no other members of negotiating team, including someone who would have been the team commander, Sergeant Mole would still be employed. The decision to allow the smoking of the blunt as part of a surrender agreement, if that had been the decision, would have been approved by the team commander. That would have been the highest decision maker, not Sergeant Mole.
And so in other words, right or wrong, if Sergeant Mole had a team commander to make this proposal to, and the team commander had said, yes, that makes sense. We have somebody who's threatened suicide. In fact, he's discharged his weapon. Yes, that makes sense. Then the team commander and not Sergeant Mole would bear the risk of whether or not that decision satisfied the department.
Correct. The team commander would have been the final decision maker. And we don't know what would have happened. Maybe the team commander might have said, no, we're not going to allow that. And maybe the suspect blows his brains out upstairs, or maybe the negotiations continue and the suspect smokes the marijuana upstairs and there's a success. We don't know what would have happened.
Sure.
But had there been other members of the negotiating team, as the policy required there, Sergeant Mole would not have been the final decision maker with responsibility for making that choice.
Excuse me, does the team commander have additional training? Does he have more training than Sergeant Mole had?
I'm not real clear on that. The team commander would have more experience, had been on the negotiating team longer. This was, in fact, Sergeant Mole went to the FBI school in May of 2014. This is June 2016. This is the very first negotiation that Sergeant Mole was ever involved in. Never called out to a negotiation previously. Also, there's another policy we rely on that was violated, and that's General Order 1022. That policy specifically requires quarterly training among members of the hostage negotiating team, and it required annual interaction and training between the hostage negotiating team and the special enforcement team.
Excuse me, if I can ask you sort of a bigger picture question.
Sure.
Tully holds that the plaintiff had to show a clear established rule or policy regarding the employment promotional process that furthered a legitimate governmental interest. For the sake of argument, let's assume that that would apply to not just a promotional policy, but retention policy, termination policy. The policies that you're arguing about are not process policies. They have to do with function, and you have a causation argument that but for these things, Sergeant Mole would not have been terminated. Can you help this panel understand how we get from the holding in Tully and extend that holding to policy violations that are more attenuated from the employment process?
Well, Your Honor, it would seem to me, I mean, we do cite to some of the employment policies generally. In particular, this is, I believe, paragraphs 20, 29, and 30 of the complaint make reference to the employment policies, and particularly Durham City Policy, HRM 322. And among other things, those policies require, at least we allege, fair treatment of employees and things of that nature. And it's, I think, a more attenuated argument. I mean, the amicus brief from the FOP basically says Sergeant Moley did everything right, and he was fired for doing everything right, and that's a Tully violation. To make that argument, the violation that the department and the city did would be the violation of the employment policies. And we think those exist. And so I think that is the way to get to that point. I do not think that Tully is limited to the promotional process. I mean, they're particularly, they're very favorable site to United States v. Hefner, where they say, and I quote, "An agency of the government must scrupulously observe rules, regulations, or procedures which it has established. When it fails to do so, its action cannot stand, and courts will strike it down. The doctrine's purpose is to prevent the arbitrariness which is inherently characteristic of an agency's violation of its own procedures." I think that Tully has a much broader reach than just the promotional process or that just the employment policies. In fact, there is the distinction, and King versus City of Chapel Hill was the government acting in a regulatory fashion. And that was part of the argument against the Tully decision. And the court said, no, even acting as an employer, and that's what they say, as an employer, they must follow their policies.
And so, and that's a helpful reminder that we went from King to Tully, and so far I haven't seen the floodgates open.
That's right.
So far I haven't seen the floodgates open. But when we go from Tully to this case, and there's a policy of fairness, and you want to prevent the arbitrary firing of an officer, how do you square that with the at-will employment doctrine in North Carolina? And, you know, in Tully, that was not an issue because it was a promotion case, right?
Sure.
So how do we, was Sergeant Moley an at-will employee?
Mr. McGinnis has an argument that he wasn't.
Okay, we will wait to hear that.
I believe as a matter of the personnel policy, they probably say that he was, okay? But, Your Honor, to get to that point just quickly, Article 1, Section 1 makes the ability to exercise and perform your profession a fundamental right protected by our Constitution. And I think in the public employee context, that modifies the at-will doctrine. You know, in the private context, you can't bring a First Amendment free speech or an Article 1, Section 14 free speech claim against a private employer. I was exercising my rights of free speech. We don't care. We can get to fire you anyway. So public employees have more protections, and Article 1, Section 1 is one of those more protections. If you don't have any questions immediately, I need to defer to my co-counsel.
Thank you.
Mr. Marshall, could you engage the Judge Inman, Judge Zachary, Judge Carpenter? Good morning. May it please the court. I would like to begin with what I believe is the most important part of this case. It is the text of the North Carolina Constitution, and we make a textual-based argument. What our framers gave us was not one equal protection clause, but two equal protection clauses. These clauses appear in the latter portion of Article 1, Section 19. The first equal protection clause begins with the text, "No person shall be denied the equal protection of the laws, semicolon, nor shall any person be subjected to discrimination by the state because of race, color, religion, or national origin. We respectfully suggest and argue to this court that what that text shows is that the second equal protection clause is what this court has recognized as suspect class disparate treatment or discrimination. The first equal protection clause is not so limited. It is broader. And it is our position before this court that when the framers gave us no person, that means law enforcement officers, and that means Sergeant Michael Millay.
Would you say that that's a class of one argument, or is it something different?
It is a class of one argument, Judge Inman, and our primary precedent for that proposition is a case called Toomer versus Garrett from 2002. That was essentially the first time that this court had construed under our state constitution that principle. And this court held in that particular case that North Carolina does recognize non-suspect class discrimination so that all persons, including law enforcement officers, would enjoy the same benefits under our Constitution as everyone else. Judge Inman, I'm sorry, there's a second case that follows Toomer that is a more recent case. It is cited and argued in our brief. It's from 2016 of this court, the town of Beech Mountain versus Genesis Wildlife. And there is the following language that I think that might be pertinent to the court. Quoting the court, it is clear that governmental actors cannot single out a particular individual or entity for disparate treatment based on illegitimate, political, or personal motives. Cite several cases. Such purposeful discrimination against a particular individual violated the Constitution even where no recognized class-based or invidious discrimination was involved. So this court now has a settled precedent consistent with our state Supreme Court ruling in Durham way back in 1992, saying, and firmly saying, that the North Carolina Constitution is independent, it has teeth, it is enforceable, and we've seen the line of cases where this court has in fact shown that our Constitution has teeth and is applicable to protect law enforcement officers.
And would you argue that the town of Beech Mountain therefore distinguishes the U.S. Supreme Court's decision in Inquist? Because that is a concern in which the U.S. Supreme Court squarely held a public employer isn't subject to a class of one disparate treatment claim.
Judge Inman, of course, you're absolutely correct. That's an Inquist case, is one that the police community followed. We were disappointed with our U.S. Supreme Court's holding in that case. But Toomer would be the controlling law we submit on the issue before this court.
But Toomer held that the guarantee of equal protection provided in the 14th Amendment to the federal Constitution has been expressly incorporated in Article 1, Section 19 of the Constitution, and thus the same analysis will be applied to both. But you must argue, of course, that it's not the same analysis. If it were the exact same analysis, wouldn't Inquist control here?
Well, I think we would still have the distinction, Judge. Inquist would control under any 14th Amendment analysis for sure.
Okay.
We didn't even open that door. We did not plead or allege the 14th Amendment.
Okay.
This is one where we thought our Constitution was the better argument and in all due respect, the better law. We think it's distinguishable. Judge Bryant, in her dissent when Tully was before this court, she got into Inquist and went down that road, but we saw how our Supreme Court handled that. Our Supreme Court in Tully didn't follow Inquist in any way.
And just to follow that, and I'm asking a lot of questions, but if the 14th Amendment is expressly incorporated into Article 1, Section 19, is it your argument that, yes, it's incorporated, but there's more there?
Yes.
There's more there in Article 1, Section 19?
Yes.
Which is provided. Okay, thank you.
And, Your Honor, there's a case from this court, Evans versus Cowan, that is cited in the briefs, which we think gives a good analysis of how, because our state constitution has got more detailed and specific language that, again, a textualist approach would suggest, maybe we get a little more equal protection in North Carolina. And the law enforcement community needs that equal protection. Your Honors, getting back to, for just a moment, the heart of the case in the record before Your Honors is you have a complaint. And the facts that are in that complaint, as alleged by Mr. Payne and I, are the pertinent facts for you to consider. We have pled in exacting detail. We submit in many areas, even in our factual assertions relating to our equal protection claim. You will see many specific instances that we didn't just do a boilerplate citing the elements to stay in the court. We gave the court some meat, and there's simply not time to go over all of those examples, but what has happened in Durham, in all due respect to Durham, they have essentially, in this case, adopted a practice of no good deed goes unpunished as it relates to Sergeant Millay, who saved the life of Mr. Smoot. But when you look at what we've pled in its entirety here, we have pled a pattern of practice that Durham has condoned some serious police misconduct, very serious, some of which is criminal in nature, and those officers were not fired. And Sergeant Millay, on the other hand, who was dealing with, most law enforcement officers might suggest, one of the worst scenarios. Your Honors can't hear that gunshot going off in this courtroom, but Sergeant Millay did. He was all alone, as Mr. Payne illustrated. The policy was a team approach. That makes sense. They put Sergeant Millay in harm's way. We are lucky that in that split-second environment that he was in, that we didn't have the loss of life. His good judgment, his exemplary service for his years in service is what got him through that moment. And what we're left with now is a pleading which shows, we submit in some exacting detail, how there's been a pattern of practice of condoning serious police misconduct, and a good deed comes along, and he is the one that's terminated. And that is why, Your Honors, that it's arbitrary. That is why, moving from equal protection to substantive due process, we've got those cases and those principles in here. That is why that principle should be underscored here too. And in fact, Judge Inman, in the Beach Mountain case, this court there gave excellent distilled summaries of the doctrine of substantive due process. And we submit in this case, it is particularly arbitrary because we have an issue of officer safety present. We have public safety present. And shouldn't that arguably trigger what our law professors taught us to mean some strict scrutiny, a compelling governmental interest? The saving of lives, whether it's the public or police officers, ought to be a very important interest. This court has historically protected that interest, and we're asking you to protect that interest today for Sergeant Millay.
Mr. McGinnis, if I could just, on the due process, and again, I'm sorry to interrupt your argument, but this court has held that a liberty claim under the Due Process Clause requires the plaintiff to show that he has a protected liberty interest, right? And am I understanding your argument that Sergeant Millay has a protected liberty interest because of the situation here in which we have a law enforcement officer whose own safety is at risk, the public safety is at risk? How do you propose the analysis would go in this case that would not provide, are you asking for a blanket holding that law enforcement officers have a liberty interest in continued employment so that there's not at-will employment ever with respect to them?
No, Judge Inman, I want to answer your question,
Sure.
but my light is on. We are not asking for that sort of a blanket ruling. We are asking for a narrow ruling in this case because of the particular level of what we suggest is egregious violations by Durham of its own policies. It wrote the rules, and the United States Supreme Court back to the 1950s said when a governmental employer writes the rules, the government should live by those rules. But finally, Judge Inman, we're not banking our due process argument only on a liberty interest. There's about 4 property interest arguments which we've made in the brief, and we suggest that they are very specifically supported by the pleading. We've argued that Durham has a practice and custom of affording due process, and we've seen that in their policies. They represent that in their policies. So we think there's about 3 or 4 different ways that this court should find a property interest and a liberty interest as well. Since my time is up, I will sit down. Thank you, Your Honors.
Thank you very much.
May it please the court. My name is Henry Sappenfield. I'm from the law firm of Ken & Craver in Durham, North Carolina, and I have the privilege of representing the city of Durham in this matter. It may be too simplistic of a way to begin, but I think it's a key point, one that didn't quite get discussed in the summary of the case law. It is a long complaint, which has a lot of allegations. However, it does not provide specific facts that establish the legal elements to the claims alleged. Moreover, it does include facts which actually defeat some of the specific claims.
Mr. Sappenfield, if I could just ask you a question that I think on the mind of maybe everybody in this courtroom.
Yes, Your Honor.
At a time when our state and nation are facing a crisis of public confidence in whether law enforcement officers protect and serve some of our most marginalized citizens, based in part on incidents in which mentally ill suspects have been killed by responding officers, how does your client defend its decision to terminate a hostage negotiator left out to dry without the team that was supposed to be there, who successfully disarmed a barricaded suspect after that suspect had discharged his weapon?
Yes, Your Honor. And that goes to the direct point here, which is Mr. Mole, and it's discussed one way in the initial brief, which is Mr. Mole was terminated for telling the truth. It's a somewhat misleading statement. Mr. Mole was terminated for allowing a suspect in custody before being booked to commit a drug offense in front of him. And the very same allegations set out in the complaint detail how Mr. Mole was subject to an internal affairs investigation. Mr. Mole, that matter was taken up by his superior officers. His superiors recommended that he be demoted. And then it goes up all the way to the chief of police, who's been doing this work for a much longer than any of us have as an administrator and as an officer of the law, who said, no, the commission of a drug offense by a suspect in custody whenever an officer could have prevented it is something that I don't think should lead to demotion. It should lead to termination. Mr. Mole then grieved that process, and that decision was upheld. And it goes to the direct point of the amicus brief here, which wants to focus on the policy and say, Your Honors, what you need to do is you need to now decide what's the correct policy that should be had here and what needs to be done in this situation. I don't know enough about law enforcement to know why the commission of a drug offense in custody is worse than the alternative of not fulfilling everything that's set out in the surrender agreement. But it goes to all of the direct claims here. Going initially to Tully, you hit some of the same points that I wanted to address, which is in their brief, they say that Mr. Mole, Sergeant Mole, allowed a suspect to smoke a marijuana cigarette in his presence, and the chief of police made the decision to terminate him, and that he then grieved that decision. And Tully involves I believe Tully involves a clear requirement of but-for causation, because as plaintiffs state in their brief, they say that Durham intentionally failed to comply with its own policies, which proximately caused the conduct in question and resulting injuries to Sergeant Mole. But the word proximate causation isn't in Tully. That issue doesn't get discussed. Going through the actual issues in Tully, the sergeant in Tully, he was up for the rank of sergeant and was taking the written exam. And in that, he did not receive a passing score on the examination, not because he was wrong, but because he was right and the law had changed. That was a direct violation of the City of Wilmington's policy that required employee examinations to have, quote, demonstrated contest and criterion validity. Then the plaintiff in Tully sought to grieve that decision, and he was told that test answers were not agreeable by item. That's a direct violation of an express policy that candidates may appeal any portion of the selection process and that retesting may be required if an error in the process is substantiated. Here, what we're talking about is much more attenuated. Sergeant Mole wasn't terminated for how he handled the agreement. Sergeant Mole was terminated for the fact that he abided by both terms of the surrender agreement and allowed the commission of a drug offense in front of him.
If Sergeant Mole had been given the timely notice that was required by the Durham Police Department policies, I think he was given 24 hours notice, and that was substantially less than the required notice.
Yes, Your Honor, we're talking 3 days for a
3 days. 3 days.
disciplinary conference.
If during those 3 days, I don't know, perhaps other hostage negotiators with the department, I don't know, a lawyer, any other resources that might have been available to Sergeant Mole if he'd had the required notice.
I don't think it does, Your Honor, because Sergeant Mole was terminated for conduct that he admitted participating in, or he admitted facilitating or allowing to happen. What gets set out here is he would have had more of a chance to express himself. First off, he went all the way through the process. There was the internal affairs investigation. There was the pre-disciplinary conference that he got to participate in.
Was there a critical incident critique?
There was not a critical incident critique, and that's even more attenuated because, Your Honor, a critical incident report or a summary of the issue would not have changed what he said happened. It would not, to provide more context, the chief of police was not required to take that context into account. Now, we may here today say, well, the chief of police should have decided that differently. Maybe the chief of police should have, in her own discretion, based on her own experience, made a different decision. But that wasn't what's required, and that goes to the direct point of causation, which is a whole series of policies are mentioned, but all of them are removed a whole step away from what happened in Tully, which was direct. And if we're going to get into a Paul's graph-like idea of what causation is and all of that, then this court will now be reviewing, presumably, employment decisions for public employees that are not otherwise handled under personnel acts. So,
Mr. Summerfield, if Sergeant Mole lies and says, I didn't let him smoke the marijuana cigarette, does he still get terminated?
Your Honor, if he had stated that falsely and it was discovered, then he would be terminated for...
So what message do we send to the officers when it's okay to lie and when it's not? Because in essence, what the city would have him do is lie to the suspect that he's coaxed out unharmed, and then not fulfill the deal, in essence a lie, but then not lie to the city. So the question is, when's it okay and when's it not? How do we split that hair?
Well, yes, Your Honor, that is something which this court and all courts have contended with for a long time, which is we need police officers, law enforcement officers to be forthright and trustworthy so that we can trust them on the stand, but we also need to have them be in a position to have the flexibility to do what they need to do to fulfill their jobs whenever they deal with the public. And I would say, Your Honor, that here it was the very fact that he allowed the commission of the drug offense. I think it would be a fundamentally different decision, and we would be in a fundamentally different place if the issue was that the City of Durham had a policy that if you enter into a surrender agreement, you must abide by the terms of the Senate in the agreement.
And that's the role that the commanding officer that was required to be on scene per the policy would have made, correct?
Well, that's an interesting idea. The idea of the commanding officer on the scene and that relevance actually just comes from a single allegation. It's allegation paragraph 139. It said, had the rest of the hostage negotiation team been called as present, as policy requires, all demands would have been considered by the hostage negotiation commander, and Sergeant Mole would not have been alone to serve in those roles. Now, this court is not, on one hand, is supposed to take the four corners of this document, but at the same time, it's not required to accept unreasonable inferences, legal conclusions. I would submit to this court that what you've been presented is a what-if scenario. And
But we're at the 12B6 stage.
yes, Your Honor. And at the 12B6 stage, this court is still not required, it is required to accept all factual allegations, but it's not required to make unreasonable inferences. It's not required to accept conclusions of law. Here, if that is what it is tied to, then it hangs by that very narrow thread, which is the idea that, yes, that even though it's not in here, that a superior officer could have made a different decision or would have known to make a different decision.
Well, if a superior officer had said, no, don't promise that. We can't keep that promise, don't promise that. Sergeant Mole might not be terminated, assuming he'd followed that advice. If the commanding officer said, yes, do that, and I guess I'm asking, what's unreasonable about the inference that Judge Carpenter has hypothesized?
Well, I think the unreasonable part of that inference is without specific factual allegations, that there was in fact a superior officer who would have had the ability to make that decision and would have had that superior control. What you've heard what you've heard argued here today goes beyond what's actually in the four corners of the complaint. Just like the amicus brief wants to tell you about what the right policy is and what the right way to do it is. We're constrained by what's actually here. We're constrained by the decision that the chief of police has to make about her staff.
Well, has the city, by agreeing to be fair in its discipline, agreed not to act in an arbitrary manner or to engage in selective enforcement of personnel policies? Or?
Well, Your Honor, I'll go ahead and touch on that. If you're asking about the class of one equal protection idea that's set out, I think that the complete procedural due process entitlement that they would have, although I believe that Sergeant Mole does not have a property interest in that, and I think that's amply demonstrated in the case law. I think there is no general entitlement to a full due process, full right to handle employment decisions. And I think that gets directly covered in the by the Supreme Court whenever they discuss the Class of 1 claims in the context of Inquist versus Oregon Department of Agriculture.
What's your response to, I believe it was Mr. McGinnis's argument, it may have been also Mr. Payne's argument, that following the Beach Mountain case and some other precedents they cited, that the scope of Article 1, Section 19 is broader and provides greater, more detailed protection than what Inquist was addressing?
Interestingly, I actually don't have a strong preference on that because I feel like that, let's say that it does, and I think it could potentially. I don't think that it changes the end result here because Toomer versus Garrett talks about Article 1, or Article 1, Section 19 being receiving the equal protection rights under the 14th Amendment, and that the same analysis can be applied to both.
But does the fact that that Toomer held that the same analysis can be applied to both preclude this court from holding that when you have that Article 1, Section 19 is broader, and so that additional analyses can be applied? I mean, maybe that's semantics, but.
No, Your Honor, I think it's an important point. I think because of my analysis of the case, I think that the better view of it based on the actual case law is that they're coterminable, and that just as this court, just because Toomer talks about equal protection, but it talks about it expressly in the context of a Section 1983 claim under the federal Constitution, and finding that the actions there were arbitrary and capricious, and there was no rational basis for the release of the complete personnel file. But the federal decision being referenced there was Villa v. Willowbrook versus Oliek. Oliek was decided prior to Inquist. And the federal part of that, as we know, has changed with the adoption of Inquist.
But Mr. McGinnis is arguing that we're not arguing federal constitutional law. We're arguing state constitutional law.
Right, Your Honor. And I think arguing it under the state constitutional law, so I think Toomer doesn't apply because that discusses it under federal law. Federal law has changed. Federal law has recognized that there is no class of one theory in the context of public employment. And this court, that's even been recognized by this court as to federal equal protection claims in Gilreath versus Cumberland County Board of Education. But here, I think that even if this court were to say, okay, we're going to look at it solely under our state equal protection clause.
Which is what the claim is, right?
Right. But Your Honor, there's two levels of scrutiny under equal protection claims. Strict scrutiny applies only when the classification is impermissibly interferes with the exercise of a fundamental right or operates to a particular advantage of a suspect class. But this court has previously held in Krieger versus North Carolina Criminal Justice Education and Training Standards Commission that the right to work and earn a livelihood under sections 1, 19, and 35 of the North Carolina Constitution are evaluated under the rational relation to a substantial government purpose. And rational basis merely requires that there be, the government classification bear some rational relationship to a conceivable legitimate interest. In the instances where it's appropriate to apply it, the Government Act is implied to a presumption of validity.
And it would be your argument that that decision binds this panel
That is, Your Honor.
from applying any higher level of scrutiny.
Yes, Your Honor, and I believe it's particularly applicable because that case involved an officer who was sanctioned for falsifying a training certification form. And his argument was that it was an unfair, it was unfair to him because others who had other violations were not sanctioned to the same degree. But there, the court said that that there was a legitimate public interest in maintaining training and certifications, and that by itself was enough. Here, there is enough of an interest in allowing the police department to make its rules as to how its officers interact with the public, and finding that a police officer not allowing the commission of a crime directly in front of them while the suspect is handcuffed is important to maintaining their relationship with the community.
Well, if you look at the interest in Krieger, let's call the whole thing off, how you pronounce it, that is in promoting public confidence in police officers, right?
Yes, Your Honor.
That they tell the truth.
Right.
It's not about allowing a police department the flexibility to discipline its officers.
Right, Your Honor, but there is a public interest in not having police officers allow the commission of crimes.
Okay.
And you're right.
So you would say that, and if there are two conflicting legitimate interests, it's your argument that all you need is one legitimate interest.
Yes, Your Honor.
And that even if there's an argument that there's a public interest in hostage negotiators having full discretion and keeping their promises, that it doesn't need to, if there's conflict, it goes to the department.
Yes, Your Honor, it's any conceivable interest
Okay.
under the rational basis review. And I think to the extent that this court looks at it, the Supreme Court's decision in Inquist is really telling as to the importance of having that, going back to the idea of flexibility, the Supreme Court notes, unlike the context of arm's length regulation, which is the other case they cite, treating seemingly similarly situated individuals differently in the employment context is par for the course. It's no proper challenge to what is of nature a subjective and individualized decision that it was subjective and individualized. And I think all of that leads to the reason why the equal protection claim fails as a matter of law. Turning briefly to the procedural and substantive due process claims, I do not believe under the case law of this court that there is any liberty or property interest at issue here. All of this has been dealt with before in employment cases. A property interest and employment can arise when created by a statute, an ordinance, or an express or applied contract. Here, none of those are alleged. Mole doesn't allege that he has an employment contract with the city. He doesn't allege that the city's policies and procedures were incorporated into a contract with him or been enacted as an ordinance. And I think that is by itself, with the decision in Wooktie versus McNeil, sufficient to say that you are an employee at will. And those same rules apply. Now, Mole makes the argument that he is a permanent employee, and that gets talked about both in the complaint and in the briefs. And because he was employed by the city from May 2007 until he was terminated in November 2016. But this court previously held in Roberts versus Wake Forest University back in 1982 that generally where there's no expression of a duration of employment, it's an indefinite general hiring and therefore terminable at will.
Sure. And I didn't hear Mr. McGinnis echo that again today. But what I did hear him say is in the context of police officers working on the front lines in a situation with an armed citizen who's threatening his life, but also the life of the officer and other members of the public, that in that context, law enforcement officers have a property interest, have a liberty interest. And he said he's not asking for a blanket ruling, but could you just address what would be wrong with making that kind of exception?
Yes, Your Honor. First off, I don't know how, it would have to be created. It doesn't exist. There's a reason why it's not cited in case law. Second of all, I don't see if you had that ruling, how that is not a blanket ruling. How is that not, anytime that the law enforcement officer is dealing with the public in a dangerous situation that any employment decision that comes out of that is now reviewable by this court. I don't know what the limiting principle to that would be other than any time that you're in a dangerous situation and you're being asked to create something which does not exist. There's a reason why we started with a discussion of Article 1, Section 19 and its broadness. But we're dealing with case law, and we're dealing with what this court has previously found and what still binds this court. And I think there's the Tully claim that we discussed. There's the equal protection claim, class of 1, asking this court to find that exists here. There's the procedural due process claim and the substantive due process claim. And briefly, the procedural due process claim rests on the idea of the opportunity of notice and the right to be heard. The very allegations in the complaint are that there was an internal affairs investigation, presumably, it's not stated in the complaint, but presumably done by an experienced law enforcement officer that was reviewed, and that that matter was reviewed by his superior officer, Sergeant Mole's superior officers, and that they all made decisions or made recommendations about what discipline was appropriate, and they all recommended discipline. And then it got up to the highest rank, and the chief of police said, no, the discipline of demotion is not sufficient for what's gone on here. I believe termination is appropriate. And the substantive due process claim has to have a rational relationship to the state objective. And here it has to both shock the conscience and be arbitrary. I would say that the decision to terminate an officer who is allowed the commission of a drug offense of somebody who's handcuffed and in custody does not shock the conscience. And it has a rational relationship to the state objective that we discussed previously, which is the state interest in police officers not publicly permitting the violation of the law whenever they are in a position to prevent it. And I'm happy to cover any of this in more detail, but I think that briefly summarizes all the points I wish to make.
Do you have any more questions? Do you have any more questions?
Would the successful negotiation of the surrender of an armed hostage or armed, it's not a hostage, it wasn't a hostage situation, but an armed individual who had fired a gunshot, would the firing of the guy that successfully did that shock the conscience? Because what we're trying to do with the case is parse out these two entities, but they're interlocked with each other. He successfully, the city, as I understand it, praises him getting the guy out with no one being harmed. It's what happened after that the city has issues with. But they're locked together. Certainly we can argue about their separability, but they're intertwined. Your argument is it doesn't shock the conscience that the city would fire someone that allowed the commission of a crime in his presence. Would it shock the conscience if the city fired someone that, in the same set of circumstances and facts, successfully negotiated the surrender of an armed individual in this situation?
Yes, Your Honor, I think that gets to the key point, which is, as I admitted at the beginning, this would be a very different situation if what I had said, if what the facts were alleged is that there was a City of Durham policy that if you enter into the terms of the surrender agreement, you must abide by them. Just like if Sergeant Mole had said, listen, I've got you in custody, I'm sorry, I can't let you smoke this marijuana cigarette, but you can see your son, I'm glad to give you some more time with your son, you know, I want to make it right. There's no violation. There's no IA investigation. There's none of this. It is the affirmative decision by that officer that led to it. And I get that they're inextricably related because it doesn't seem fair, and we want to say, Chief Davis, you made the wrong decision because I'm really bothered by it. But, Your Honor, there is the need for flexibility of administrators in public employment to make decisions about what the right thing is to do, and they have expertise and knowledge that I don't have. And they need to be able to administer that fairly within the confines of that role. So it may not be the decision that we like, but it is a fair and appropriate decision under the circumstances. And the decision to allow the smoking of the marijuana cigarette by Sergeant Moley was made by Sergeant Moley. No, he was not forced to do so.
What's the crime?
I'm sorry?
What's the crime?
The crime is...
Would it be possession of marijuana? There is no crime for consumption.
Right.
So it's possession of marijuana. Would it be an infraction? That's
I believe that that would be correct, Your Honor.
okay. Thank you.
Wasn't that infraction already happening?
He was not smoking the marijuana cigarette, or he's not alleged to have been smoking the marijuana cigarette, or
But he already had it, right?
he already had it, keeping in mind that he said that he had it. Sergeant Moley, from the four corners of the document, can't see the guy all the time. It's not clear, it's not alleged in here that, oh, I know that you're possessing marijuana. He does get told that he's possessing marijuana.
But Sergeant Moley wasn't fired, for example, for not taking it from the suspect.
Right. Right, Your Honor.
The suspect had it.
Yes, Your Honor.
He was possessing marijuana
Yes, Your Honor.
without Sergeant Moley doing anything.
Yes, Your Honor.
Okay, thanks.
Thank you.
Mr. McGinnis, before you get rolling, what's the material fact that a jury needs to decide that's not decided by application of the law? I just want you to think about that and let us know before you finish.
It's an excellent question, Your Honor. When you look at the answer in this particular case, the core allegations have been admitted. This may very well be a case for summary judgment for the plaintiff, given the unique facts before this court, Your Honor.
Thank you.
Your Honors, I want to try to real quickly hit a few points based on your questions and obviously whatever further questions. It seems that Durham is overlooking the fact that there is a fundamental constitutional right in issue in this case, as our Supreme Court has determined and found in the King case and then in Tully. Fruits of one's labor is a fundamental constitutional right. The point in this case here is we have the strongest possible argument for it, we contend, because of the clear arbitrariness. What is so, I think, unique in this case to me, having attempted to represent police officers for 37 years, and what I routinely hear is, Mr. McGinnis, your client has violated this policy, and this is why. And in this case, it is clear that Sergeant Moley was acting within policy.
Well, and then the city later made a policy later which doesn't apply. But if you could respond to Mr. Sappenfield's argument that, this is a unique case, but he's argued that this court would be creating a different class of employment plaintiffs, all law enforcement officers, anytime they're engaged in any public safety or dangerous situation.
Well, Your Honor, we respectfully disagree, but we're not attempting to go that far. We're simply saying examine the Tully approach as to the importance of the fruits of labor. That gives us an underpinning there that is a liberty interest type of protection as well. Maybe there's some differences there, but they seem to be similar. And if we apply a fundamental rights analysis requiring a compelling governmental interest, again, in this case, we think the compelling governmental interest is the saving of the lives of the public safety, and the officer safety. Jumping to Judge Carpenter's question about lying here, they've got him boxed in. If he would have lied, we know the general position is police officers are often appropriately fired for lying. The Wetherington case has given us some exceptions and limitations to that. But surrender agreements, Your Honors, are very important. As the amicus brief has demonstrated, people in the streets, people in the community know that. And as Judge Inman has pointed out, here we're at a unique time in the United States of America when the integrity of the police community is under attack. And this court should not take the road that Durham would apparently have us take now, to be lying to people when there's police operations. That is not a good public policy.
How do we get around the rational basis test applied in Kruger?
I'm sorry, I couldn't.
I said, how are we not bound by the rational basis test that was held in Kruger versus North Carolina Criminal Justice Education Training and Standards Division?
Your Honor, although I can't presently recall the unique facts of that case, Tully changed that. Tully gave us fundamental rights. In fact, and there are other North Carolina Supreme Court cases prior to Kane which gave us a fundamental rights analysis. And I don't know if there's tension or conflict between that and Kruger, but the gravamen of this case is Tully. And as to counsel's suggestion that it hadn't been specifically pled, it is all over the place at paragraphs 57, 86, 87, 174-182. We specifically pled causation. We're not in a Paul's graph analysis. It's not that kind of a tort. The pleading is very specific. Something overlooked here, which relates to the arbitrariness issue. The entire chain of command in Durham didn't see a termination offense. Only when it got to the chief. We don't know what her thinking is, but we know what the city put in its brief on page 1. Millay was terminated due to his decisions and actions during this successful negotiation for his peaceful surrender of an armed subject on June 28th. And he was within policy, and it would set a horrific example if municipalities are authorized at whim to say, well, officer, you're within policy, but you're getting fired anyway because we don't like something about what you did after the fact, when at the same time they handicapped Sergeant Millay. And Judge Inman, you are exactly right. Sergeant Millay was hung out to dry, just like Algie Toomer was 20 years ago, with massive disparate treatment. It's not like Durham was running a objective, clean, fair personnel system.
If you will wrap up, because you've exceeded your time. And
I'm sorry, Your Honor. I should have been watching that light. On the courthouses around North Carolina, we usually see an inscription of equal justice under law, and that's what equal protection is, and this case cries out for it. Thank you very much, Your Honors.
thank you very much. The case is submitted, and we're going to be in a very brief recess and do a very quick swearing in. You have just a few minutes. Okay. Thank you, counsel. We're going to be at ease while Cynthia Hernandez and her family approach. Oh, that's after the next one. Sorry. Thank you. We'll be at ease until 11 o'clock. Thanks.
All rise.
Sorry, Valerie.
This session of the North Carolina Court of Appeals is adjourned.